Guys, fasten your seatbelts. We're delving into Chavez's legal catastrophe today. When the judge begins Chase Bank versus Chavez, he tries to guide him through the paperwork and interrogations, but Chavez starts to play games right away, claiming he hasn't received all of the information. He starts making vague references to sovereign citizen nonsense rather than dealing with the fundamentals. Despite his patience, the judge is obviously dubious about the direction this is taking, claiming to be putting up a defense. Chavez is actually only buying time. You can tell the circus is just getting started when he makes a suggestion that he will require documents prior to his actual defense.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared, and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe. I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements.
It's okay, folks. This is when things get crazy. Chavez begins distributing his purported bank findings. Such content is typical of late-night sovereign citizen forums. The judge asks him a straightforward question: how much is left? And when is the payment due? Avoiding it, Chavez turns everything into a crazy theory. He asserts that the bank borrowed from him and that he is the true lender. For someone so incorrect, his confidence is astounding. He then intensifies his demands, claiming that the bank had stolen his personal security. It's not a defense at this stage. It's an obvious case of hallucination.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, I've been researching the law and, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure and, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. That was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those
So,
are the questions.
okay, my defense is I am the lender and they borrowed from me.
The judge now makes the unambiguous decision that enough is enough. Chavez owes the money since he used a card, but Chavez refuses to give up. He shifts the topic to gap accounting, saying that everything changes because this application generated a credit. The judge moves on to the actual matter, summary disposition, without wasting any more time on this fiction. Although the law is simple, Chavez believes that jargon will help him. The judge locks in January 9th as the date for the subsequent hearing. Chavez is unable to avoid reality, no matter how he presents it. Whether he likes it or not, the lawsuit is proceeding.
What did they borrow from you?
My personal security, which I'm
No,
entitled to.
no, I'm not buying that. No. Listen
Okay.
to me. Listen.
It's not about. I have it. This. I'm going by the law, Your Honor. I'm not just making
No,
up
you're not
anything.
going by the law. You're making up the law as you go along. You
Is
took
that-
a credit card out. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card. And you didn't pay on the card. They don't owe you anything.
So So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. All right, 1 second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th. The
Okay,
clerk's indicating.
I will get that out right
summary
away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
Hi, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of, I talked to them in the chat, they confirmed it. And I have they gave me a bill credit for inconvenience, so that's why I wasn't able to attend, because I was having problems with the internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So, here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
The narrator tells us that although the first case is mostly over, Chavez is still humiliating himself. Discover Bank vs. Chavez is about to begin. He begins by making an excuse this time. His Xfinity internet was down, so he missed court. Despite acknowledging the notice, the judge does not absolve him. You need two things in order to set aside default: a good defense and a legitimate reason. Chavez never has anything more than excuses. Despite the judge's detailed explanation of the regulation, it completely bypasses him. Due process is not a meritorious defense, the narrator continues, and you realize Chavez is already cornered with nowhere to go.
Okay, all right, here's what we're going to do. I'm setting a date. So what, do we need discovery on this? What, Mr. Gothal, so this is a credit card bill.
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands.
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all.
When the court investigates the bank's claim, Chavez's case immediately collapses. His own response does not refute the fact that he pulled the card there. His defense breaks down on its own. A textbook example of debt law, the court explains, is an account stated with the initial creditor. The legal hammer follows. The court can make a decision right away if the pleadings alone demonstrate entitlement. At this point, the court states unequivocally, it clearly is. Chavez isn't even aware that he's lost yet. The bank just left with everything, while he entered with nothing.
All right, we're all set. Thank you,
have
Mr.
no
Arnold.
words.
Mr. Arnold, I ruled against you.
I
am
have
allowed to
evidence.
do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Chavez takes a final, desperate stand at this point. He tries to delay the inevitable by waving affidavits around like they're magic shields, but the judge doesn't budge. those documents are meaningless. A summary disposition is given, the Discover Bank judgment has been entered. Just now, Chavez lost another lawsuit. The judge then chastises him, emphasizing that he squandered everyone's time with arguments that have no place in a courtroom. When the judge declares, "We are done," you can hear the finality. Thank you. The next sovereign catastrophe is set up by the narrator before you can catch your breath. The Sherman Moore Circus will soon